Let's talk about why DHS keeps grossly distorting what the Constitution says about ICE immigration arrests. It's public statements that they've repeated so many times that a judge called them out for doing so in December of last year. And in January, in just the last few days, they keep doing it. And I'm going to show this by dissecting what was a viral video of Tricia McLaughlin, the Assistant Secretary for Public Affairs of DHS, in a CNN interview. And I think by decoding what she said and what she didn't say, it can show to you a hidden agenda on the part of DHS and this administration of a policy that eviscerates constitutional rights. And the right in particular that I'm focused on is going to be the Fourth Amendment, which fairly straightforwardly says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. And not only does the policy eviscerate constitutional rights, but what I want to talk to you a little bit about at the end of this is how that might implicate President Trump's possible invocation of the Insurrection Act. And I want to break this down for public education and as well for reporters and journalists that interview DHS officials and the like. This all began on Thursday in this most recent episode with Secretary Noem suggesting that Americans need to carry with them proof of citizenship and show it to ICE agents if asked to do so. That was outlandish, and Assistant Secretary McLaughlin appeared on CNN to answer to that question.
Secretary Noem also told reporters yesterday that ICE may ask people to, quote, validate their identity when asked about Americans carrying proof of citizenship. Mm-hmm. Can you clarify what exactly that means? Do American citizens, as of now, need to carry their passports or other immigration documents to show that they're citizens?
I am so glad you asked this question because I think that there's a lot of confusion there about this. We have incredibly targeted immigration enforcement operations. So what's happening there is reasonable suspicion. If somebody is in the vicinity of this operation, of this target, then they could be asked for their identification.
So if you listen to what she said if somebody's in the vicinity of this targeted immigration enforcement operation, they could be asked for their identification. That's outlandish. The idea that somebody just being in the vicinity of an ICE operation would be suspect, and the legal definition, which we'll get into in some greater detail, that there's a reasonable suspicion that they're not a citizen or not in the country lawfully, just because they're in the vicinity of the immigration enforcement operation, would never hold up in law. And that is actually what Secretary Noem said.
In every situation, we're doing targeted enforcement. If we are on a target and doing an operation, there may be individuals surrounding that criminal that we may be asking who they are and why they're there and having them validate their identity. That's what we've always done, in asking people who they are so that we know who's in those surroundings. And if they are breaking our federal laws, we will detain them as well until we run that processing.
I'd looked for other instances of people referring to being in the vicinity of an operation as though that makes them suspect. That is what she said on Thursday. So Ms. McLaughlin is actually doubling down on that. That's an enormous dragnet if that would be a sufficient basis for reasonable suspicion that somebody's not a U.S. citizen and that they would therefore have to carry with them their ID. Ellie Honig pointed out the same thing.
That is quite a stretch. Why would standing around an ICE operation tend to indicate that somebody is in this country illegally? I think that would be a really hard one to justify in a court.
I just want to double back on some other aspect of what Kristi Noem said. She said, quote, there may be individuals surrounding that criminal that we may be asking who they are. Now, the word criminal is doing a lot of work there. First, just for a point of clarification, something that often gets lost in the discourse and conversations about this. Individuals who are non-citizens who overstay their visas are not committing a crime. That is not a crime in the U.S. It's a civil violation, not a crime. Second, those individuals who do cross the border, the U.S. border, without authorization have committed a crime. It sounds ominous, people surrounding the criminal. Their crime is a misdemeanor. So Tom Homan often tries to say these people have committed crimes. The crime they've committed is a misdemeanor if they cross the U.S. border without authorization. And for most of them, the statute of limitations has run. So to still call them a criminal is quite a stretch as well. Then let's follow back on Assistant Secretary McLaughlin and the next words that she spoke.
We've been vindicated by the Supreme Court, September of 2025. You all saw a case out of Los Angeles where they said we can use a reasonable suspicion.
So I'll get to in a moment what it means when she says that the DHS's position has been vindicated by the Supreme Court in September. No such thing. But listen to her words. She said, you all saw a case out of Los Angeles where the Supreme Court, said we can use reasonable suspicion. Here's partly what's hidden here. Reasonable suspicion for what? Reasonable suspicion to do what? The sleight of hand is actually where her sentence ends. Her next sentence is no longer about reasonable suspicion. It moves to other things. But what the DHS is doing is they're saying that reasonable suspicion is a sufficient basis to arrest people. That is false. It's if that were an individual's answer on the bar exam, they would fail that question. And if they answered other questions on the bar exam the same way, they would fail the bar exam. It's that black and white. So the sleight of hand is that DHS does in fact believe that they can arrest people on the basis of reasonable suspicion, which is a very low standard. We'll talk about it in a minute. But when DHS, for example, tweeted out that interview on CNN, in fact, their tweet said, law enforcement uses reasonable suspicion to make arrests. Well, I guess the answer is thank you for at least telling us, because that's clearly illegal. And then DHS doubled down again in case you thought that was a slip. Later that afternoon, they said, in response to a media outlet, false. A person's immigration status makes them a target for enforcement, not their skin color. Law enforcement uses reasonable suspicion to make arrests. We'll talk also about the racial implications of what they also were trying to deny there. But here's the just straightforward chart of what is required for an arrest versus what is required for a brief and limited stop. For an arrest, it is required that law enforcement authorities have probable cause. Probable cause is a much higher standard than reasonable suspicion. And with reasonable suspicion, the only thing that ICE agents can do is briefly stop somebody for a limited time, like a couple minutes, for questioning. In both instances, they have to have particularized information about that specific individual that makes the ICE agents suspect that that individual is either in the country unlawfully or probably is in the country unlawfully. And that's a highly particularized determination. But there's a mismatch here by suggesting that reasonable suspicion, the lower standard, would give ICE agents sufficient basis to arrest people and cart them off. Assistant Secretary McLaughlin said that they were vindicated by the Supreme Court. What is she talking about? So in September, in a decision called Noam v. Vasquez-Perdomo, the Supreme Court did favor the U.S. government in the case, but they just put everything on hold. They gave no explanation for why they put it on hold. That's number one. Number two, what she's referring to is a concurrence by one justice, Justice Brett Kavanaugh. Just in his concurrence, one of the things Brett Kavanaugh said in his concurrence is that the first reason he's affirming the government's position is that he thought the plaintiffs didn't have standing. When he's saying the plaintiffs didn't have standing, what he's saying is that they should not be able to bring this particular complaint into the court, and then he talks to the merits of what their complaint would be. So the court upholding or vindicating the government, all they might have been doing is just saying the plaintiffs could not bring this particular complaint to the court, but it doesn't mean that the government's action is legal. But all that said, I stand with Brett Kavanaugh in the sense that Brett Kavanaugh, in his opinion, says the black letter law. He says things that are completely consistent with the chart I showed you. He said, for example, importantly, reasonable suspicion means only that immigration officers may briefly stop the individual and inquire about immigration status. In other words, they cannot arrest the individual. Then Justice Kavanaugh emphasized that point and elaborated that point in a decision in January. So in a decision in January, he's definitely speaking about the same subject matter. And he went out of his way to say the Fourth Amendment requires that immigration stops must be based on reasonable suspicion of illegal presence. Stops must be brief. Arrests must be based on probable cause. I even wonder if he was speaking to DHS, because DHS has repeatedly misstated the law. And when I say they have repeatedly misstated the law, I mentioned there was a judge in December who called them out for it. Not only did she call them out for it, but she called out in particular the Assistant Secretary McLaughlin. In that opinion, Judge Beryl Howell addressed the plaintiff's complaint. The plaintiffs had argued that DHS was arresting people who live or work in the District of Columbia, and whom they perceive to be Latino, there's the racial element, without the required probable cause finding that those individuals are in the United States unlawfully and are likely to escape before an administrative warrant can be obtained. The judge went on to say, finding that defendants have implemented such a policy and practice does not require a far leap of logic. Defendants themselves have repeatedly emphasized an abandonment of the probable cause standard. For example, Tricia McLaughlin, DHS Assistant Secretary for Public Affairs and the Principal Advisor for Secretary Noem on all external and internal communications, has made public statements confirming this point. On September 25th, 2025, in response to this lawsuit, McLaughlin, a DHS spokesperson, is quoted as making the following public statement about the very lawsuit, okay? Quote, allegations that DHS law enforcement officers engage in racial profiling are disgusting, reckless, and categorically false. Under the Fourth Amendment of the U.S. Constitution, DHS law enforcement uses reasonable suspicion to make arrests. That's an admission of guilt on the part of DHS. That is not a vindication. Then she says the Supreme Court recently vindicated us on this question. False. The opposite. Judge Howell goes on to say, the same day DHS's official social media account at DHS.gov posted the same statement, again reiterating that DHS uses reasonable suspicion to make arrests and that the Supreme Court recently vindicated us on this question, which the judge is calling them out for that because it's patently false. Then one of the most remarkable passages in the judge's opinion is quoting what happened in one particular incident in which he says Chief Border Patrol Agent Gregory Bovino, who's now become infamous, told the press, sorry, that's my language, it has now become infamous. She says, Chief Border Patrol Agent Gregory Bovino told the press, quote, we need reasonable suspicion to make an immigration arrest. You notice, I did not say probable cause, nor did I say I need a warrant. We need reasonable suspicion of illegal alienage. That's well grounded within the United States immigration law, end quote. Absolutely false. And that's what Judge Howell was calling them out for, and I am sure other judges and courts will be doing so in the future as well. She also notes reporting that it's said that when a former acting U.S. attorney for the Eastern District of California told Bovino, so DOJ attorney themselves told him that he could not make civil immigration arrests without probable cause, she reportedly was fired. So what's the upshot of all of this? I think the upshot of this is twofold. One, there is a systematic policy on the part of DHS and ICE to engage in a dragnet in which they are arresting people and carting them away without sufficient basis, that it is a clear violation of the U.S. Constitution, and they're saying it explicitly. The second is the Insurrection Act. So this is a little bit more of an advanced point, but here's how it goes. If President Trump tries to invoke the Insurrection Act, he will do it on the basis of a pretext or allegations of unrest. In some scenario, maybe that's true, but let's talk about the scenario that's in our real world. If it's about Minneapolis, he will have stoked the unrest. ICE and DHS have engaged in aggressive, and from what we've just been discussing, absolutely lawless behavior that even on the face of it, what they say about it is lawless and anti-constitutional. And there's a principle in law, international law, which I know a lot about, and domestic law, which I know a lot about. The principle is if you invoke an emergency power, you cannot do that if you yourself, or the government itself, or the state itself has contributed to or caused the emergency. You can understand why people are outraged at the ICE tactics. The ICE tactics flout basic constitutional protections and the very historical reasons that we even have the Fourth Amendment. So to try to bootstrap the Insurrection Act onto that, I think, is a deep problem. So thank you for listening. Please make comments in the comments section, and I'm happy to engage with folks there as well. And if you appreciated this conversation, then you might also appreciate another one I recently did, a video with Tom Jocelyn, a friend, colleague, and a leading expert in democracy and domestic extremism. We discuss NSPM 7, which I hope becomes more of a household term, because more people need to know about it. National Security Presidential Memorandum, which suppresses First Amendment activity and is being utilized, as far as I can tell, by this administration coming out of Minneapolis in different ways, or at least the tactics that they're using seem to graft directly onto the framework of this presidential memorandum. Tom and I discuss it with respect to the investigation and the smearing of Renee Good. Thanks, everyone.